Welcome to the Women's Voice, which is a platform for women rights initiative, where we discuss issues affecting our societies, our communities. Um, you're welcome, our viewers. In studio today, we have our special guest, a counsel for Women Rights Initiative. She's a legal aid officer, and she will bring herself. Welcome.
Thank you. Thank you so much. I'm happy to be here again. My name is I'm called Bali Esther. I work with Women Rights Initiative as the legal aid officer. Thank you so much, Jackie, for hosting me today.
Okay. So today's topic is about the procedures the procedure of filing a court case. What is it that an individual has to know before filing their cases in court? So my first question, Esther, is who can file a case?
Okay. Thank you so much. If you start with who can file a case in Uganda, we have the law mandates anyone who has a claim. Any claim that you have whatsoever, as long as it's justifiable before the provisions of the law of Uganda, you can always file the suit. You can always file a case. Yes. So maybe what you can look at is that it also depends on what claim you have against someone or what kind of claim you have. That's what justifies what you can file. For example, there are cases that the civil and also criminal cases. You find that when someone has a criminal case, its filing process is different from that of a civil case. If you have a criminal case, which means it's an offense against the state, usually that process of filing is different. But if you have a civil one, you can always just do paperwork and take it to court. Yes, that's what I can say.
Thank you, Esther. Thank you, Esther. So what is the procedure for filing this case in court?
Okay. When we specifically look at the civil bit of it, whereby it's an individual against an individual, you find that you have to first know who are you bringing the suit against, which person who offended me, and what have they done? Have they maybe have they frauded me? Or let's say maybe they're taking your land, trespass land. There is trespass, that's civil, and there is also criminal trespass. You find that if you ascertain who is supposed to sue, sometimes you can sue a company. You have to first know, does this company exist? Does it have the legal mandate? Or if I'm suing an individual, are they saying, like, do they have that brain? Are they of age? Because you can't sue an infant except they can sue through a next of friend. Or am I suing a person who is still alive? Or am I also suing the right name? Because if I come and say Stella Namlondo, it's very different from Jackie Namlondo. So it can't be brought against you. So first of all, that's the first procedure that you have to ascertain, is that, are you suing the right person? We have examples whereby someone has aliases, whereby you find, okay, let's bring from the artist that there is Bobby Wine. Bobby Wine has a name. It's sent so if you only attach Bobby Wine, it's his alias. So you have to first know, is who am I suing? What is their name? So after that, when you find that you've found the right person, the right name, you can go ahead and see, what offense do I have against someone. So you find that there are very many laws that provide for various offenses that can be brought against someone. But however, you can't sue someone for what is not provided for in the law. For example, trying to sue someone before 18, having sex, it's not an offense that is provided in the law. if they're all of mature age, 18, 18, except if it's rape or if it's anything. So you have to also first know is that the case that I'm alleging, does it exist? Is it provided for in the provisions of the country, the nation? If you know that, then there is something we call the course. Which course are you going to take to ensure that your grievance or your got justice? We have various ways of filing suits. Various ways those suits can be brought up in Uganda. The most common way is the plaint by way of plaint, whereby it's an ordinary. We have that is we also have under Order 36, whereby it's a summary suit. If maybe you entered into a contract with someone and you signed that contract, and the contract says that you're supposed to be paid 2 million shillings, and has defaulted, and you're just claiming that 2 million shillings, you don't need to go the ordinary way. You can just file a summary suit, whereby a summary suit is expected to file a defense after certain days, and once those days elapse, and the person has not filed their defense, then you're entitled to a default judgment. And then also, someone can bring a suit, something called chamber summons. And then we also have various applications, and that someone can bring a suit against someone.
Thank you, Esther. So, how, if you could kindly describe for us the kinds of suits that can be brought against someone.
Okay. Against someone, there are two kinds of suits that can be brought against someone. There is a civil suit whereby it's between you and me, which is practically things that affect individuals on an individual basis. For example, I was supposed to do for you something, and then I have defaulted to do that something, yet I've already taken your money. It's between me and you, like it's affecting Jackie and Esther. However, there is whereby it's between an individual and a state, which is another criminal offense. How it comes up, it's like when you had a citizen of a nation, let's just say citizen of the nation. If you had a citizen of a nation, for example, rape, we have defilement, aggravated defilement, we have robbery, we have aggravated robbery, we have murder, we have all those. Those are those are cases against the state because you're harming an individual, or you're harming a citizen of Uganda. So it's the government who is prosecuting you if that happens. But however, if it's in the civil way, it's Jackie versus Esther. But in criminal, it's Uganda has a nation against Esther, who has maybe murdered or defiled or done something. So those are the two kinds of suits that can be brought against someone.
Okay, there is some question that has come up. Do you think with the criminal suit, if this person, the victim, or I would say that they call them the plaintiffs, right?
In
If
criminal,
the plaintiff pulls out, yes, if they pull out of that case, like let's say they've found a way of settlement, does that mean a witness, or does that mean that's the case?
well, if I've got your question right, whereby the complainant wants to settle, it's a criminal matter. Well, what I can say is in a course of procuring justice, the justice system is built in a way that it unifies. It's not built in a way that it is dividing people. That's not its aim. But however, the offenses whereby if there is overwhelming evidence, you will be prosecuted. But however, if the complainant, maybe the state does not have sufficient evidence, or the complainant is not willing to testify, there is no need for an innocent person to be prosecuted. it's better for you to be exonerated than to be prosecuted, whereby the complainant is not there. They're not willing to give evidence. They're not willing to come to court. They're not willing to do anything. So most times you find that the state will always recuse themselves from that case, or if there is really overwhelming evidence otherwise, sometimes state will go ahead and prosecute. But if maybe from the beginning the complainant is not willing to, they don't come to court, they're not willing to come, they're not willing to do ABCD, you'll find that the state can always enter something called non prosecute, or is pray to court for such a matter to be dismissed. Maybe. But for settling, according to Ugandan ways, most people settle, which is not right. Sometimes justice needs to be achieved, but however, when also administering justice, we apply the laws of unification. That court is trying to find a unifying ground that even at the end of the day, when these people live in court, let them not go divided, but let them go when they're still unified, that they can still live in society together. Yeah.
Okay, thank you, Esther. So with a civil suit, can someone end up in jail in case they fail to settle? Is it possible for court to sentence this person for some time, to serve some time in jail, in prison?
Well, not particularly sentencing, but when you find that once a civil suit has been brought against you, and actually orders and judgment has been granted not in your favor, but in the favor of the other person, there is whereby now you're realizing the amount that was in the civil suit, whereby we go to executing the orders that have been granted by court. You find that in executing civil matters, someone may be the judgment debtor who has won, the person who has won this suit, decides that the only way I can get my money from Esther is let her go and serve some jail time. Her parents will panic, the relatives will panic, they'll try and pull resources for me to recover my money. So you find that yes, someone can be sentenced to civil prison. It's called civil prison, not it's not like the other criminal bit, but it's civil prison. And there is a time frame where someone is not supposed to exceed being in a civil prison. So yes, it can earn you jail time, but that jail time comes in a way of someone is trying to execute against you to see how they can recover the money they have won from the case from you. So if they want to recover from you, and the only way to recover from you is by you being in civil prison, then yes, you can go to civil prison for some time, which is usually, you're not supposed to exceed 6 months in civil prison.
Thank you, Esther. So who can file, when can one file a case?
Okay, when you look at especially civil, okay, first of all, in criminal cases, if someone has a criminal case against you, a criminal case can always start. It's never closed. It is forever there until justice has been achieved, or until something. A criminal case never expires. Even if it's 100 years, they're still investigating for those 100 years. And by the end of the 100 years, they realize that you indeed committed this crime, you'll always be charged for it. But however, when you go to civil matters, there is a time frame whereby if you have a claim against someone, you're not supposed to exceed that time frame. For land matters, it's 12 years. 12 years from the time when you started realizing that person is trespassing on your land. You have 12 years, but if the 12 years elapse, maybe now on the 13th year, that's when you're waking up to realize that this person trespassed on my land. You can't bring a complaint against them when 12 years elapse. And then we also have for contracts, it's usually there is a time frame for also bring a matter that is contractual in a way that you contracted me to do something for you and I've defaulted. So yes, the law provides for time frames in which these civil matters should be brought, and equally, the law still provides for the time frame when someone who has been sued should respond to this. For an ordinary suit, when an ordinary suit has been brought against you, you have usually 14 days to respond to whatever has been sent to you. Yes.
Okay, thank you, Esther. So what are these steps for a civil trial? What are the steps involved during this whole process?
Okay, for a civil one, you file. First of all, okay, just to paraphrase it, you could get a lawyer who can advise you on what you know. We read through the fine lines. We know what can stand and what won't stand. If you get a lawyer, they will make paperwork for you. They'll draft the paperwork for you, and then it's taken to court. And then when it reaches court, that's when it has been filed now. It's in the registry, and file number, case number has been given. Then the matter can be set down. Nowadays, we have what we call summons for direction, whereby you apply to court to guide you in case maybe you want to make maybe applications, maybe if it's land, you want to be granted an injunction. Injunction is like they first of all stop any work on the land until the case has been decided. It's brought up on that stage. Then after that stage, you go for something we call scheduling. Scheduling is whereby court sits and both parties are around and maybe there are lawyers around, and then they see between the plaintiff and the defense that has been filed, where are these two people agreeing from? What facts are being agreed from? Usually, you could argue that yes, I'm the individual who has been sued, and then also the other person says yes, I'm the individual who has sued, and then the second thing you could agree on, maybe if it is land, you can agree on the location of the land, and then you can agree on who is in actual possession of that land at a particular time. So once that step is done and your summons for direction they have been had, and then also the scheduling has been done, then the next step you go to the hearing of the matter. So when the matter has been set down for hearing, it's usually the plaintiffs who start because it's the case. They're the ones who reported. So they'll go ahead and hear the evidence that the plaintiffs have to say. Maybe they'll bring their witnesses. Usually they could bring maybe five or as many witnesses as they can. Or court will direct them to write witness statements. Usually, not all of them are heard verbally. So sometimes court will direct them to file witness statements. And then once the plaintiff's case is closed, or once the plaintiffs have filed witness statements, then the defendants also, their evidence will be heard, then it will be the defendant's case, and then they will also bring witnesses, they will be heard. After that, or maybe they'll also be asked to provide witness statements, they'll also come. So once the process of hearing the witnesses is done, then it may be then there is also cross examination because when a plaintiff files or when a plaintiff gives evidence, then the defendants are allowed to cross examine. Maybe if I have witness A today, then the defendant's counsel or the defendant has a right to ask questions in regards to what they have said. And the asking of this question is like, I'm trying to build my case or I'm trying to discredit them for us to know that they are not genuine people or whatever they're saying is a lie, you know. And then the same story comes to the defendant witnesses that when you bring witnesses and the defendant's side, the plaintiffs are also allowed to cross-examine them on whatever they are saying. Then once the hearing of evidence in chief and cross-examination is done, we go to the next step, which is now the submitting stage. This is whereby the counsels usually filing submissions or orally give submissions in court. Then, once the submission stage is done, then they can go ahead and give judgment or ruling. If it was an application, they can go ahead and give judgment or ruling. And then once judgment has been pronounced in court, then we go to the execution stage. This is now whereby you're realizing whatever has been the orders that have been given in court, you're now executing them. So now this is where, remember where imprisonment comes in. It's the stage where I say, okay, I can recover my money from Jackie if she's in prison. Now this is the stage after the whole process is done. So that is the process in which legal matters are done.
Thank you, Esther. There's a question I had. Is it necessary that you have to have a legal counsel, like, for you to get some justice, let's say in the civil suit?
Yes, it's your mandate, it's your right, but however, it's not absolute. You can decide to present yourself if you can. I mean, if you can, there are people who represent themselves, but the problem comes from usually we advise people to get lawyers because of the technicality. Because you can't be unpresented and your other party, the other person is represented, and you think you stand a chance with someone who studied that much to know to read between the lines. You know, there is you having facts of what happened to you, yes, and then there is also technicalities in law that should not overbe looked because for you right now, maybe if you file a suit against me, you may think that it's very clever for you not to let me know, and for you may think it's a good move, yet in actual sense, it is damaging your own case. Because if you bring a judgment against me, I can say, but she never summoned me. I never received any summons to come to court. So if that happens, if someone can plead that, then you've probably not done anything. So yes, it's not mandatory, but where you can, or seek help from legal personnel. Except Jackie, except if it's in criminal matters. In criminal matters, especially when someone has done there is a criminal matter which is a nature of a capital offense, you are entitled to hire a lawyer. However, if you can't, then it's upon the state, it's upon the nation, it's upon Uganda to provide for you that lawyer. So usually they have lawyers who on state briefs. Those are, you know, so it's upon Uganda as a nation to give you a lawyer it's because the matter that has been brought against you is one of a capital nature. Yes, Jackie.
I think I've kind of lost you, Esther.
Oh, you didn't. Oh, sorry. Can you hear me now?
Oh, I've got you back. Thank you. So, in a hearing, what are the steps that for there's a scenario? One lawyer one time told me he was representing a client in court, and the client kept on pushing him. You say this, say this, say this, and some of them don't understand the steps that are involved in a hearing. So, what are those steps involved in in the hearing of a case?
As earlier on told you, in the hearing of a case, there are usually very many steps involved, as I earlier on explained to you. Because sometimes you may find that you as a client, you want something to be heard, but as a lawyer, I find maybe it's not helpful at this particular stage that you are in. For example, you want us to talk about let me say to talk about the works that are you want us to talk about ownership, yet we are talking about getting a temporary injunction at a particular moment. Ownership does not matter in an injunction because you're trying to see how is the subject matter, how is this land being saved until that time. when the suit shall be decided on. So, as I told you, the steps that involved in a hearing of this case, there is a filing process, then there is a hearing process, whereby both parties will be deciding on what hearing evidence from each other's side. Then, however, when that part is done, then you have the judgment stage, and then after the judgment stage, you always have the execution stage. So those are the various steps that always happen in civil matters.
Esther, a quick question. Is it possible, let's say it's a criminal suit and it's the state versus, let's say Jackie, and
Uganda
the
versus
state,
Jackie.
Uganda versus Jackie, and then the case is won by the defendant. They call them
Yes,
defendants. Yes.
yes.
Is it possible? Let's say it was your case, but then the state took over. Is it possible for the individual, let's say you, Esther, is it possible for you to appeal?
No, once the state takes over a case, and it's a criminal case, as an individual, if I feel dissatisfied, I can always go back to the state because I'm always the complainant. I know the evidence and I know what. Yes, the appeal can be done, but however, it's still the state to file that appeal, not the individual.
Okay, so it's the state that has to continue with that. You
Yes,
can't
it's
get
the
a
state that
private.
has
You cannot. That means you cannot get a private lawyer to
as long
push
as
on
you're
the case.
complainant, as long as you're complainant and and it's Uganda versus someone else, you can't. It always has to be the state
Okay. So
because the matter is not against you; it's against the nation.
okay.
Yes.
This is it the same with the civil suits?
No, for the civil suit, if you feel like the judgment was not fair enough, you can always make an appeal. You can make an appeal as an individual if you're so knowledgeable and you feel like you can do the paperwork for yourself. Yes, you can file the civil appeal. But however, even you can always change lawyers on appeal. You can maybe say, in hearing this matter, it was Esther who was in this matter, but I felt like she was not so knowledgeable enough. Let me go to Jackie. Let Jackie now handle my appeal. And if you feel like Jackie also let's maybe say it started with the magistrate court, and then you contract Jackie to go for the appeal in high court, and then you still feel Jackie also wasn't good enough, you can always go for Rose. It's in civil matters, it's up to you as an individual to decide who do you want to represent you, when should they represent you, and then you can always withdraw you can always withdraw your instructions from them at any particular time. And you can always contract someone else. The only bit is that it gets tricky when it's criminal cases. Criminal cases is strictly the state who has to handle it. But in individual civil matters, you can contract as 100 lawyers as you want, as long as you can, of course, give them the instructions they deserve and the fees. You're capable of the fees, then you can always contract as many lawyers as you wish to have.
So there is
At
no
any
representation on a civil suit. There is no representation from the state.
No. Because you've not offended the nation, you've offended an individual. So
Okay.
it's a one-on-one, yes.
Thank you, Esther. We've come to the end of the show, and we appreciate sparing us your time. And I would like to thank our viewers who have been watching our show. Please continue doing that. You can also subscribe to our YouTube channel to get notification on when we have these kinds of conversations. Thank you very much. Have a great day.